Hey everyone. I want to take a few minutes to talk about judges and jury selection and how that process works in light of the recent Supreme Court decision about the Flowers case. As you know, I have sent you some discussion about the Flowers case, and it was a case out of Mississippi where the individual, Mr. Flowers, has been tried by the trial courts there in Mississippi 6 times on the same murder charge, and each time there has been a concern about whether or not the prosecution inappropriately excluded African Americans from the jury. So what I wanted to do was take just a few minutes to talk about the jury selection process and kind of what that's supposed to be about, and then I'll talk a little bit about Batson claims and the kinds of things that are relevant to this Flowers case. The purpose of having a jury, as you probably know, is that the individual who's on trial can essentially be tried by a jury of their peers, people in their community like them who are able to kind of review the circumstances of the case and then be able to make a determination about that defendant's guilt or innocence. And so what we try to do in the selection of juries is to try to get an impartial jury, theoretically. The Constitution asks that we get a jury that hasn't already made up their minds or have some sort of bias against the person who's been charged. And the way that we do that is we take a selection of the people in the community where the crime was committed, and we try to pull all those people together and take a sample of those folks to serve on the jury. And in the beginning stages of that, what we do is the courts will send out a request demanding that you show up to court on a particular day to serve for a jury. Those are randomly selected people who end up on those juries. And the idea is that those folks will show up and they'll be able to kind of cull out the people who might be biased so they can end up with an impartial jury. Okay. Typically what happens is, typically what happens is about 20% of the people who are asked to show up just don't show up at all. And nor you could essentially, and theoretically, you could go after those folks and say they were in contempt of court and track them down. But typically what happens is there are enough people who show up at the courthouse on the date that they're supposed to be there that they don't often send officers out to find the people who were supposed to show up. From that group of people, they try to select a core group of people who will be able to sit on a jury who won't have some sort of bias related to the defendant in that case. Most folks who show up for jury duty may not initially be selected for a particular trial, but once that jury core group of people gets in there, then when they get into the courtroom, they learn what the case is that they're going to be participating in, and the defense and the prosecution get a chance to knock those folks off of the jury if they don't if each party feels like the potential juror might be bad for their particular version of the case. So essentially what you start out with is you start out with this jury pool, and it's really just supposed to be the people who've not convicted a felony who are living in the jurisdiction where the crime has taken place. And from that group of people who get the initial summons to come to court, those folks show up at the courthouse. That sample of people shows up at the courthouse. And then ultimately through the process of voir dire, which is kind of a funky word, meaning the process by which the defense and the prosecution question the jurors to determine whether or not they may have some sort of bias, you essentially can get down to a group of people who will sit on the jury. Through that voir dire process, so once we get all those jurors into the courtroom, the judge, the attorneys can ask questions of those potential jurors to decide if there's any sort of bias that might prevent them from being able to sit on the jury and render an impartial decision. Really, the two major things I want you to kind of get from this, and that as they relate to this Flowers decision, are the types of challenges that attorneys can make. Attorneys, if they feel like there's some sort of bias that an individual may have, they can challenge for cause, meaning, let's say I get summoned for jury duty and it's a robbery case. If a judge or each of the attorneys ask questions and learn that I was involved in a robbery as a victim, they may kick me off of that potential jury because of some potential bias that I may have because of my involvement in being a victim of a robbery. Okay, so that would be a challenge for cause, meaning that the attorney has a reason for kicking me off a clear reason for kicking me off the jury. Okay, the other type of challenge is a peremptory challenge, and each side gets a certain number of peremptory challenges that they can use any way they want to. They don't have to have any sort of justification for why they kick a potential juror off of the jury. So they get these are like free passes. They can just kick those folks off. The idea behind that, a lot of people think that it's kind of to try to get an impartial jury, and theoretically that's how it's supposed to work. But really what you're doing is each side is trying to exclude people from the jury who might not fully subscribe to their version of the case. Okay, their theory of what happened. So we have challenges for cause and peremptory challenges. The challenges for cause, like I said, can be for anything, like the victim, the defendant, you were a victim of a particular type of crime. Peremptory challenges are just they're sort of free challenges where you can just have somebody kicked off for no clear reason. Where this becomes an issue, and particularly as it relates to that Flowers case that we were talking about, is that you can kick people off for cause, but you can't kick people off simply because they belong to a certain race. So in the Flowers case, it's an African-American, Mr. Flowers is an African-American defendant who was accused of murdering these 4 people, 3 of whom were Caucasian. And in each of those 6 trials, it appeared to the defense attorneys and to ultimately to the Supreme Court that the prosecutor was kicking off African American jurors essentially to stack the jury to make it so that it was almost exclusively a Caucasian jury. And why that is a particular issue is for this community where this crime took place, it's the majority population is African American. So it seemed a little weird to people that if the majority population is African American, that your jury, which theoretically is of your own peers, is made up of people outside the majority race that was in that community. And so many times, this most recent decision was the 6th time it's happened, but the case made its way to appellate level courts where they said that the DA had violated the Constitution by kicking off people who are of a certain race, particularly in this case African Americans. And this relates to the original case, Batson v. Kentucky, where an African American individual was charged with a crime, and in a similar sort of setup, the prosecution was challenging and kicking off jurors who were Caucasian to stack the jury presumably against him by using Caucasian jurors. And I've put a link to the Batson case. There's a podcast and some other information related to that in some of the documentation for this lecture. The important thing to know is that you cannot kick somebody off of a jury simply because they have certain characteristics or particularly racial characteristics. And that's why it was such a big deal in the Batson case and now most recently in the Flowers case.